Okay, let's see, Mr. Vernon, are you ready with Mr. Cheex case?
Yeah.
On record in People versus Robert Cheex, case number 245327. Council for appearances now.
Sierra Coke on behalf of the people.
And we're on behalf of Mr. Check, who's present, standing to my right. And we have reviewed the PSI. We have a couple of changes we'd like to make.
First of all, Mr. Cheex, did you have a chance to go through that pre-sentence report and talk to Mr. Vernon about that?
Yes, Your Honor.
Mr. Vernon, what are the?
So on the cover page, under personal history, it identifies physical handicaps. It says no, he has several physical handicaps. This is one of the things we'll get into here. But he has, so that physical handicap should read yes.
Oh,
I have no personal knowledge. I don't object.
okay.
And then under evaluation and plan, which is page 1 of the report itself, last sentence above the compass chart identifies the defendant has medical issues and has been on. I'm sorry, that's part of the reason we wanted physical disabilities back there. Under the description of defendant's description of the offense, which is on the following page, it identifies in the last sentence that falsely accused of calling DHS on her mother, who she was taking, and then it says of. I think there was a word missing. Everything was supposed to be taken care of. So we'd ask the court to enter that.
No objection.
Okay.
And then my client and I will both address the nature of that statement, but I don't, again, that statement's not incorrect in and of itself. So those are the only corrections we have. No challenges to any scoring or.
Okay, Ms. Koch, do people have any additions, deletions, or corrections?
No, Your Honor.
And do you have any victims that wish to address the court today?
No, she is not present today. She indicated she had to work today.
Okay. Anything that you would like to say on behalf of the
Your Honor, my victim advocate has been in touch with the victim. She indicated on that day, she called him Bob. Bob was having a bad day, which I think probably rings true. He's 69. He has no juvenile record, no misdemeanors, no felonies. I think the delay in the 7694A is appropriate given his criminal history, the victim's feelings on the case, and the overall facts of the case. And I understand that Mr. Cheex is going to address his denial in his response. Thank you.
So a couple of things to start with before we get to the statements that Mr. Cheex has made. If I may approach.
Yes.
If the court determines that Mr. Cheex should be incarcerated as a punishment for this offense, there are some concerns we have. Mr. Cheex is under a doctor's care. Nurse practitioner Lauren Atkinson has identified in writing that Mr. Cheex has significant pain-killing medications that he takes for an assortment of illnesses. Those include a fentanyl patch and hydrocodone. I am aware, simply through experience, that the fentanyl patch is a huge problem in the jail, and the hydrocodone is likely also going to be something that the jail won't allow. According to the letter, that would seriously affect Mr. Cheex's physical abilities and essentially his mental health. With those medications not being allowed to be distributed to him. So we would ask the court to take that into consideration. With regards to the statements that were made. Oh, I did want to say that the injuries that we are talking about, that the reason for those is he has vertebrae damage in both his back and his neck. He has he had a shoulder problem that had to have surgery on. They actually had to remove part of his left hip to accomplish the repair on the shoulder. He is identified by the state of Michigan as in need and appropriately in possession of a Michigan handicap license plate. So those things are all on record with them. So I don't think there's any embellishment here of his physical disabilities. With regard to the statement that Mr. Cheex made to Mr. McFolda in response to the defendant's description of the offense. He and I went over that, and I think this is something that Mr. Cheex will tell you, but that he understood domestic violence and to mean physical assault, to physically pushing, punching, knocking down someone, and he denies having done that. And he did not. Again, his position is he did not do that. He and I discussed the matter, and he is now aware that that there is putting someone in a position of fear for their safety or harm is also domestic violence as an assault. And he would acknowledge that the yelling and screaming that he did at the victim would have reasonably put her in a position of fear. I don't think that he is in any way trying to minimize what he did. I think there's a disconnect between what the law says and what he understood his actions to be. I think he understood that his actions were yelling and screaming and not a physical assault, and he didn't understand that. The statement, again, in his written description, or falsely accusing of called DHS, he would stand by that statement. He never called DHS. He never called anybody to get anybody into trouble. So that statement he would stand by. But I don't think he disputes the essence of both charges. The domestic violence, again, he yelled and screamed, put her in a position of fear, and he acknowledges that, and he will when he gets a chance to speak. And again, with regards to the resist and obstruct on the police officer, he's been very clear about that the whole time. He was told to put his hands behind his back. He said no, he wouldn't, and he went on to say that he couldn't do it because he had a physical disability that prohibited him from being able to get his hands back behind his back. But he admits that he refused to comply with the lawful command of that officer. So all of those facts taken into consideration, I think Mr. Cheex understands that although he didn't physically assault anyone, he is legally guilty of the two offenses that have been charged and should appropriately be sentenced on those. I don't think he will deny that, and I would ask the court to consider those when imposing sentence. I would ask the court to consider that 10 days jail would be unnecessary to prove the point that this is bad behavior. I don't think there's a likelihood that this will happen again. So I don't think that I don't think that that's necessary to accomplish the goal here. I think that with Mr. Cheex's specific and individual circumstances, placing him in jail where he's likely not going to get the medication that he needs, the fentanyl patch, the hydrocodone, along with his other pain medications, would put him at serious risk of physical injury or harm that would be unnecessary. And again, I think we can accomplish the goals of punishment and correcting the behavior through a term of probation where he's taking classes and being able to be monitored and do those things. Again, he's a gentleman who's never been in trouble before. He had a bad day, consistent with what Ms. Merlino said. I don't think that the 10 days jail will accomplish anything other than an unnecessary level of pain for Mr. Cheex. So we would ask the court to consider all of those circumstances when imposing sentence. We'd ask the court to hold those 10 days in abeyance as opposed to imposing them now.
All right, thank you. Mr. Cheex, anything that you wanted to say?
I could read my statement, Your Honor, if that's okay.
If you would like to, that's fine.
Yes, I would. On July 16th, 2024, when Miss Merlino came home from work, upset about what had transpired earlier that day, I should have walked away instead of confronting her on the matter. I apologize to the police officers for not understanding their commands. I should have explained that I could not physically put my hands behind my back because of my back, shoulder injuries that I've sustained from my accident. I've never been in trouble before. I got scared when I saw all the police officers at the house. I would also like to take this time to apologize to Ms. Merlino for what I had said to her. I had forgotten that she has been hurt by her ex-husband. I promised her when she came back on December 15th, 2022, that I would protect her and never hurt her in any way. When I was discussing this incident with the probation officer, and he asked me if I had a statement, I told him I didn't do anything wrong at the time of the incident. I didn't think I had done anything wrong. After reviewing the police video and the legal standards with my attorney, I understand what I did was a violation of the law. I look forward to working with probation and pursuing services to better help me understand alternatives to dealing with emotional, intense situation like that I found myself in on that day.
All right, thank you. I did read through the report. I'm glad to hear that today here in court, at least you're taking some responsibility, because when I read through that report, having the same point of view that the probation agent had, which is, this is a guy that wanted to get this over with, pled no contest, and then now wants to say he didn't really do it. And in my view, that's the type of point of view that doesn't show kind of acknowledgement of your wrongdoing, and hence, in my view, again, to lead me towards more of a route of punishment. Your statements here on the record today indicate that you understand now that you reviewed the law, that what you did was wrong. It certainly was. You know, you're an adult, you're 69, 70 years old.
Yes.
You know how to behave, you know how to act when there's conflict, and you've been able to do that your entire life. You don't have any kind of record, so clearly you know how to do that. For whatever reason, the situation got out of hand. The report indicates that you were consuming alcohol on that day.
A couple of beers, Your Honor, after I got done eating dinner.
Sure. And, you know, that's probably not, I'm sure any of your doctors who are prescribing this medication to you probably would tell you not to be drinking alcohol, which also tells me something about how seriously you take your medications and your physical condition. You want me to take it seriously. You want me to have that as a reason to not put you in jail. But it's not reason enough for you not to consume alcohol. Those two things don't line up.
I understand.
You can't use your medical condition as a way to get out of things and then say, well, I care about it in this situation, but when I want to have a few beers, it's not that important. I can go ahead and drink and take things like that. So it can't be both. It's got to be one or the other. Either it's a serious health condition that limits your ability to do things in life, or it's not. So I'm not satisfied you have a legitimate health condition. I'm not satisfied with how seriously you're taking it, whether it's a reason to keep you out of jail. I think what is more of a reason, in my view, number one, is your lack of any prior history, which indicates to me that this was an isolated incident that is unlikely to reoccur if we look at your entire history. I did read through the victim's statement. She kind of indicates the same thing. Victim is in agreement with the plea that was reached. So those things, I think, are more important to me in terms of the consideration here. I do think that it's appropriate to give you the opportunity based on your lack of prior history and case to avoid any kind of jail time. The court is going to go along with the plea agreement. I do want to caution you, Mr. Cheex, that the court's going to require you to abide by all the conditions of the delay of sentence in this case, and if you don't, we're going to be back here. And at that point, you know, what your behavior in violating those conditions is going to tell me is that your health, all those other things aren't as important to me. And I'm not going to use any of those as a reason not to put you in jail at that point, because you're going to have an opportunity here to avoid that. So Again, the court is going to follow the plea agreement in this case, which called for a delay of sentence as to the R&O charge. The court is going to adopt as the conditions of that delay, which you may follow standard terms. Ms. Koch, I mean, is there no contact? Is that something that needs to be included in conditions typically in this situation?
I don't think from my notes from our victim advocate that she's requesting that, so I would ask that that not be included. I mean, she's of an age where she can make that decision, I think.
So all standard terms and conditions, and that is going to be a 12-month delay of sentence. With regard to the domestic, and the court is going to include in that $130 crime victims assessment for costs of $325, the DNA testing fee of $60, $50 state cost, as well as a supervision fee of $30 per month. As to the domestic violence charge, court is going to place you on probation pursuant to 769 4A. That probation will be a 6-month period of probation and all the standard terms and conditions. The court is going to impose 30 days in the Crawford County Jail with credit for 2 days served on that charge. The court will hold that time in advance to be served at the discretion of the court. $50 state costs. Because both of these, one is a delay and the other is a deferral, there are no appellate rights at this time. Did you want Mr. Cheex to meet with you today, or how do you?
Yeah, Judge, I'm going to talk to him in the lobby here.
Okay, so before you leave the courthouse, just make sure you check in. Ms. Koch, anything further that we need to address today?
No, thank you.
Just 2 things before we're done with sentence. What was the days on count 1, the R&O charge?
What was the what?
The jail time for the R&O charge?
It's a delay, so I can't, that's not something that I would.
Okay,
do at this
and
point.
then there is no DNA fee because this is these are misdemeanors.
So we're striking the DNA fee.
Yes, yes.
Okay.
That should not.
As to the cost and fines, my client can make that payment today. He has a time to pay the remainder as well.
Okay. Good luck to go for it.
Thank you. I'm sorry? He will. He's got a bond. He's going to apply and then he'll pay the remainder.
1 second, because we can't take payment.
Well, he's going to talk to Mike first, so it'll be 10, 15 minutes. Thank you.
Let's call both matters at the same time, the Ptel and Bradley matters, case number People versus Kyle Ptel, case number 245300. And 245301, People versus Bradley. Council, put your appearances in.
Sierra Koch on behalf of the people.
Thank you, Albert. I think I'm hearing on behalf of Mr. Carl Ptel. Mr. Ptel's is saying.
Thank you, Andrew Jason Thompson. I'm appearing on behalf of defendant Alexis Bradley. She advised me by text shortly earlier. She's in the waiting room. I don't know if she's with us on Zoom at this point, but I believe she's been.
I don't see her on Zoom. Did she request to appear by Zoom?
She did. That was approved by your honor yesterday. And again, she tells me she's in the waiting room, so I don't know what the disconnect is.
There's a Mark Camrad there. Certainly not Miss Bradley. So, all right. So I guess first of all, let's address the people have a motion to consolidate.
Your Honor, I don't think that we need to go forward with that because I understand Mr. Ptel is going to enter a plea, so that wouldn't necessarily, it wouldn't be relevant for if he's going to enter a plea.
We'll call Mr. Patel's matter for, I know you called him, but let's, we can handle that, Judge.
Yes. Okay, so Mr. Kermit, can you tell me what the terms of
Yes, Judge, and it's reduced writing. I'll present the court with a pre-trial statement, but it's, Mr. Ptel would lead to count 1 CSC, we no contest plea. Reason for the no contest plea is potential civil liability. there is a sentencing agreement of truthful testimony against the co-defendant, and that Mr. Ptel will be sentenced to the bottom 1/3 of the guidelines. Mr. Ptel has signed it, I've signed it, I've reviewed his trial rights with him as well. And then I do have the felony information in a one-sheet statement from the alleged victim in this matter, MG, for the court to review. If I may approach it.
Yes. Both of that a correct statement that we offer in this case.
It is, Your Honor.
Because normally, do you sign those plea agreements? I know normally we don't present this, but this matter would ask that. And then I get a copy of that.
Yes.
Thank you.
I'm going to.
Okay. Mr. Ptel, have you had a chance to discuss this plea agreement with Mr. Gerber?
Yes, I did.
Okay. And is that how you want to proceed here today? Yes. Next square or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. And Mr. Ptel, are you currently on any kind of probation or parole?
No.
You understand that the maximum possible penalty that you can face for this charge would be up to 15 years?
Yes.
That maximum possible penalty in mind, what is your plea to that charge today?
No contest.
I should say, Ms. Koga, you confirmed the plea agreement, but you have no objection to this as a no contest plea.
I do not, and I would ask defense to stipulate, I'm not sure if the police report provided has the date of birth, but that at the time of the alleged incident, the child was 14 years old and 11 months.
It's not on this page, but Mr. Gerber, has their stipulation.
I would stipulate to that, Judge. And again, if the court wants to take judicial notice of the preliminary exam transcripts, it should be fine. That
Okay.
establishes it as well.
Okay, so it's on record.
Yes.
All right, Mr. Ptel, I'm gonna go through your rights with you. First of all, you do have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty.
There'll be no contest.
Or I'm sorry, no contest. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you have to ask the next higher court up, which is the Court of Appeals, to hear your case. If they said no, then you wouldn't have any more rights to appeal. You understand that? That would be the end of it. Also, you're entering this plea today based on agreement between the prosecutor and yourself and your attorney regarding the sentence. You should understand that if after I read through the pre-sentence report, I determine that that's not an appropriate sentence, that I could decide not to go along with that agreement. If I did that, I would notify you and your attorney of the sentence that I intended to impose. You would then have the choice of accepting that sentence, or you could withdraw the plea that you're making here today, and all those rights I told you about that you're giving up, you would get all those rights back, again, including the right to have a trial. You understand that? Do you have any questions about that?
Here we are.
Has anybody threatened you with anything to get you to enter this plea?
No, Your Honor.
Has anybody promised you anything other than what you said here on the record?
No, Your Honor.
And is it your own free choice to enter this plea?
Yes, Your Honor.
So I'm referring to Michigan State Police Report Incident Number 332103-23. Ms. Koch, have you reviewed that report, in particular page 3 of 5 of that report?
Yes,
And do you agree that that would provide a factual basis for finding of guilt as a count one?
yes.
Mr. Gerber, have you done that as well?
I have, Judge, and I would agree as well that it would, the court, not substantial.
Okay. I've reviewed it as well. I agree the court will mark and admit this as court exhibit 1. And the court, Ms. Koch, any objection to using that as a factual basis?
No,
No, sir.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
no, Your Honor.
No, Your Honor, other than what you stated with the sentence agreement.
Ms. Koch, are the people satisfied that the court has complied with statute? Or we're only taking this no contest?
Yes, Your Honor.
Mr. Gerber.
I agree, Judge.
All right, Mr. Ptel, the court finds that your plea is knowing and voluntary. The court finds that based on court exhibit 1, there is a factual basis to support a finding that you are guilty of count 1. The court will accept your no contest plea. The court will set this for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, it's important that you stay in touch. You've had problems before. It's really important that you stay in touch with Mr. Gerber so that you're ready to go on that date.
I've been, Your Honor.
Good. Before you leave today, you're going to meet Mr. Haven. You're going to meet with Mr. Haven here to set up the time for the pre-sentence.
Okay. I got a question, Your Honor.
Yes.
Hold on one second. I just want
Sure.
to clarify what,
I'm getting a phone in a couple weeks. I was gonna give my lawyer the number and whoever else I needed to give the number to. Is it possible I can get a list of numbers of who I need to give my new number to?
I can provide that with him, and I can give Mr. McFadden the number that he had, or Mr. Haven, the number that currently he can be reached at.
Your Honor, I believe that there's a automatic revocation of bond because of the nature of the offense for a minor child.
That is correct.
I would agree, Judge. That's what the statute says.
So, Mr. Ptel, because of the nature of this charge, the court has to revoke your bond. So I'm going to have you go with the officer at this time.
Your Honor,
I'm going to see if
if I have a second, my client, I believe that's her, the mark. She's using the computer at the residence center. She's at. So
Because this gets the trial off for about the next 3 days, next week, that was set for Mr. Patel.
correct. Yes.
Your Honor, that is my client. I can identify her.
All right, Ms. Bradley, I need you to unmute, please.
Can you?
Are you able to hear me? Are you able to hear me?
Yeah.
Okay. We're on the record now in People versus Bradley, again, case number 245301. The record should reflect Ms. Bradley's appearing by video today. And counsel have already put their appearances on.
Yes.
Mr. Johnson, can you tell me the status?
Yes, Your Honor. So Miss Bradley, we appreciate the court's accommodation. She's joining us by Zoom because she is at the hospital in Gaylord. I believe she checked in, Monday, with some mental health concerns and being hospitalized there. Our intent today would be to similarly enter a no contest plea. And that would be to a reduced charge of accosting a minor for an immoral purpose. That's a 4-year maximum with a further agreement to HYTA status.
Your Honor, Ms. Bradley has quite a few mental health issues, which I think probably shows today, but as the courts reviewed the police report, they're of course aware she was sort of a bystander. Frankly, we barely got the bind over because she had very limited interaction, but I have confirmed with the people who have worked with her at services that she has very strong cognitive disabilities, which is why we offered her this plea. I would hope the court would be willing to take that plea. It is accosting a minor and it's 750.145A. I did check the HYTA. If it requires a registration, then the individual has to show that they have, there's a specific language, but that they carry the burden by proving by clear and convincing evidence that he or she is not likely to listen further offenses. And I think probably the situation itself shows that, but we can address that at sentencing.
Yeah, is HIDA part of the plea agreement?
It is.
Or-
And Your Honor, we do understand that would be a factual determination by the court that HIDA would turn on that. So we're prepared to address that at sentencing in terms of why we don't believe there's a likelihood of reoffending.
My next question before we move forward any further, obviously Ms. Bradley's going treatment at this time. Both you've indicated that you're aware she's got some issues. So Mr. Thompson, in your discussions with her, do we have a competency issue here? You take this plea?
I believe she admits to plea today. I believe she can.
So,
I don't have any personal knowledge. I mean, I've never spoken to her. I just know that she has some difficulties. I've never had any information that makes me think she's reached the level of incompetent. So I think she's able to enter the plea.
okay. But Mr. Thompson, in your recent interactions with her, you're confident that she understands what's happening.
Yes.
So at this point, I'm going to go through the plea with Ms. Bradley. If it appears to me that there are issues, I may stop the plea and may have to send this for.
I understand.
All right, so Ms. Bradley, what your attorney has indicated is that you're going to enter a no contest plea here today to a charge of accosting a minor. Is that correct?
Yes, Your Honor.
Have you had a chance to talk to your attorney about entering this plea today?
Yes, Your Honor.
And again, Ms. Cope, you said the maximum penalty is 4 years.
Yes,
Ms. Bradley, you understand that by entering a no contest plea in this case, that the maximum possible penalty you could face for this charge is up to 4 years. Do you understand that?
Yes, Your Honor.
Are you currently on any kind of probation or parole?
No, Your Honor.
All right, with that maximum possible penalty in mind, what is your plea to that charge today?
Can you repeat that again?
Yep, your attorney has indicated and the prosecutor that the agreement is for you to plead no contest to this charge. And so I'm asking you if that is your plea today.
Yes.
Okay. I'm going to go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
You tell me, based on what I've just told you, what is one of the rights that you're going to be giving up today?
I am not too sure right now, Your Honor.
Okay. You're scheduled to have a trial next week in this case. You know that?
Yes.
Do you know what's going to happen to your right to a trial by you entering this plea today?
No.
Mr. Thompson, I don't know that this is going to be a knowing and voluntary plea.
I understand and agree with the court's concerns, Your Honor. Obviously, I don't want to subject my client to a trial next week, but I understand the court's concerns.
Yeah, I mean, I don't think I can take the Plea, and I certainly don't think we could go forward with the trial. So I think at this point, let's hope. I believe the court would have to order a competency.
I would understand. I don't know if Mr. Thompson could ask the questions in a way that she would better understand them since he's worked with her. I did not believe she reached the level of incompetent throughout this case, so I don't know that she has gotten there, but I don't know what's currently happened to her either. So I would defer to Mr. Thompson in the court.
Well, here's the other thing, Mr. Thompson, if you want, I mean, I don't know what she's being treated for. We could set this for a plea hearing at a different date and then see where things are at in terms of her condition at that point.
I think that makes a lot of sense, Your Honor. The court's aware I've had communication difficulties with her and that, was being hospitalized, that's posed some additional barriers. So the court is willing to set another plea hearing. I would certainly appreciate that. And I think in the meantime, I can get whatever is happening in the hospital because I don't have any of the documents. But we can diagnose anything. I know she's under treatment. Based on I know. And if that's suggestive of competency exam, I'm sure we can order one. But
Do we want
the court's approach.
to put it on the 16th and see just a couple weeks and see how she is then, and then we can order the competency so we don't take too long if we need to order it.
Right. Yeah.
Yes, I would agree to that, Your Honor.
So Ms. Bradley, we're gonna adjourn this hearing today and we're gonna reschedule this hearing for a couple of weeks. The attorneys and I believe that you need to get some further treatment and we're gonna see where you're at that point and whether or not we can proceed with your case, okay?
Okay.
So it's gonna be very important. I told you this when you were in court last time. It's very important for you to stay in touch with your attorney.
Okay.
You have your contact.
She does. And I will say this week, she has a phone and she has been reaching out. So presently she is making an effort to talk to me.
So your lawyer's telling me, Ms. Bradley, that you're staying in good contact with him now. That needs to continue, all right?
Okay.
All right, so
We're calling.
the court will trial in this case set for next week. That you believe eventually it's going to resolve.
And I think if we can maybe get her CMH worker's name, we could see if her CMH worker could be present on the 16th. I think that would help the court with a better understanding of what her mental health status is. I think she's under CMH care. She was.
Yeah, I think last time I asked, do you know your CMH worker's name at this time?
I only know her first name and it's my caseworker. Her name is Sarah. I don't know her last name. I know there's different Sarahs at CMH.
We can ask, we can get it figured out.
All right, thank you. We're going to disconnect at this time, Ms. Bradley.
Okay.
Ms. Welch. All right, Ms. McGregor, are you there?
Can you see me? My video is on.
Yeah, okay, great.
Okay. Thank you.
Okay, great. Yes, we're on the record now in People versus Brandy Welch, case number 235271. The record should reflect that Ms. Welch is present here in the courtroom today. If I can have counsel put your appearances on.
Christy McGregor on behalf of the people, Your Honor.
And may it please this honorable court, Michael Nichols on behalf and with Ms. Welch. I'm via Zoom. I can see and hear Your Honor and Ms. McGregor as well.
Okay, we're on the record here today for a couple of issues. Number one, Mr. Nichols, you filed a motion to withdraw from the case, and then you've also filed a motion regarding bond for Ms. Welch. I'm not sure which one you'd like to proceed on first.
Thank you, Your Honor. I think that the bond motion we filed, well, I know that we filed the bond motion before I received the communication from Ms. Welch terminating the representation. The withdrawal is mandatory because the client has terminated the representation for the reasons that I stated in the motion, but that bond motion was pending, and I considered that to be something that I needed to follow through on to protect my client's interests on my way off the case. It's my ethical obligation to do that. And so I did communicate with Ms. Welch, and she asked me to argue this motion for her as soon as possible. So I'd like to go ahead and make a few comments in support of the motion for a bond. Your Honor, I did file a written pleading, and I'll rely on that. In terms of the procedural issues that we raised, I'll simply adopt those, but I want to really focus on big picture matters. Here you have a person in Ms. Welch who has indicated that she wants to get help, and she's made arrangements. She's contacted both Harbor Hall, which I indicated in the motion and brief in support. She'd been to Harbor Hall previously. She also made contact with Bear River, and Bear River indicated that they can do a telephone assessment as soon as there's an order from the court granting her relief on bond revocation. And, you know, we all know, those of us who've been in the criminal justice system dealing with situations like this, that recovery is simply nonlinear. And that's all I'm going to say about that, because I don't want to be deemed as making any kind of an admission on behalf of my, I think, soon to be former client. But I did communicate with Everett Ayers, who is her significant other and an officer of the court as an attorney. He indicated that he's, frankly, eager to drive her to either facility once a bed is available. And Ms. Welch has indicated to me as of a phone call yesterday that it sounds like Harbor Hall won't have a bed until, I think the term they gave her was around Christmas time. The court's not obligated. There's no rule that says the court has to incarcerate and remand somebody until trial based on it. Let's just assume we have a hearing and the court finds that bond should be revoked because the bond was violated. There are options when we consider what bond is for and pretrial release. And I think especially in a case where we're talking about a person who's, at least on this file, charged with being a user, I mean, possession, but the facts are going to come in, I think, and it's going to be more of a use kind of a scenario. But, there's no gun alleged to be in the car, and she's not alleged to be any sort of a gang leader or something like that. So I don't think she's necessarily a threat to the community. And I think when you consider, Your Honor, the big picture, having her have relief from incarceration, so giving her a, we'll say, provisional bond so that she can go to one of those two recovery facilities and otherwise, remain in the jail until a bed is available. That is the ask here. I did submit a order by email with the pleadings, and I'll ask the court to consider granting her some relief from revoking her bond and allowing her to go get treatment.
Thank you. Ms. McGregor?
Your Honor, I have reviewed the motion. I didn't file a written response. I just wanted to orally argue that. When you look at Rule MCR 6.106, defense relies on in brief and support I-2, but if you read that, if the defendant has failed to comply with the conditions of release, the court may, pursuant to 6.103, issue a warrant. It's not required. When you're looking at MCR 6.103H, 2B, arraignment on information or afterward, at the defendant's arraignment on information or afterwards, the court having jurisdiction over the defendant may, on the motion of a party, which was from myself at the last hearing, may, on the motion of a party or at its own initiative, make a de novo determination and modify a prior release decision or reopen a prior custody hearing. which was done at the last hearing, Your Honor. That was based on Mrs. Welch's 3 prior dirty screens, and I think that day she had one with I know that you have a pretrial release service at Crawford County. When we talk about threat to the community, Your Honor, there is a threat. She drove to that those tests. She's driving under the influence. She's still using and possessing methamphetamine, which is a violation also in regards to violating the criminal law of the state of Michigan. And when we also talk about releasing to Harbor Hall, I'm opposed to it, Your Honor, and I will tell you why. Miss Welch has been given every opportunity available to have services. And I think she's charged as a second or subsequent right now, Your Honor. When you look at that, her prior case, I believe the court did allow her to go to Harbor Hall in lieu of jail. And I believe she checked herself out early during that pendency of that hearing. I think the court has done everything imaginable to help Miss Welch in her road to recovery. And so has the prior prosecutor. And I think based on that, the continuation of help, we have to look at the safety of the community. And I think that's the utmost. I always argue that in Oscoda County, that's the utmost concern as a prosecutor you have, that your county stays safe. When I look at Crawford County, she continues to use substances. She continues to drive. She continues to possess methamphetamine. All of those things, based on that, I don't believe a release. We are set for trial. I believe bond is appropriate. I believe the court followed the court rule in regards to the bond hearing. We can ask for a modification at any given point, and so can defense. And so I'd ask the bond to stay as is, Your Honor.
Thank you. Mr. Nichols, it's your motion. Anything you wanted to say in response?
I suppose my comments were not clear. On the one hand, I stand behind what we filed, but on the other hand, I think I want to just move past addressing the procedural issues and just address the issues of what I think is in the best interest of the community and this particular person who's in front of the court. And, you know, there's no evidence that the swab that is what is the basis for the presumptive positive test and the bond revocation, that's evidence of intoxication. I believe it's the saliva contains the enzyme that's evidence of what was in your body. So in terms of her being intoxicated driving to those tests, I just don't think there's any evidence of that. And I just think, Your Honor, a person deserves every opportunity to recovery, especially when we're talking about a mother of a couple of kids who I don't know Ms. Welch prior to representing her. I know she loves her kids and she's proud of her relationship with them and trying to do the best she can to come back from whatever this demon is. So I think it is appropriate. It's in the interests of the community and consistent with the purposes of pretrial release. Thank you.
All right, thank you. I did have a chance to review the brief. I'm familiar with this case and the underlying facts, as well as the Ms. Welch, the circumstances that have occurred throughout the pendency of this case. Through the motion practice we've had, I'm aware of prior cases. This arose out of an issue with one of your prior cases. Stop here. I think I do need to address the procedural issue because it was raised by counsel in the brief, and under I-2 of that subsection of the court rules, the court can issue a warrant once the court is aware that there's a basis for finding that the person has violated a condition of their release. The court can issue a bench warrant and revoke the release order, and at that point, the defendant can be immediately arrested, or they can turn themselves in within that 28-day period. And the court does have to mail notice, but there isn't anything in the court rule that requires the court to mail notice and have a hearing before the person can be arrested. They could be arrested immediately on that warrant. And whether they surrender to the court, turn themselves in, or whether they're arrested, which Ms. Welch was in this case at her last hearing, The court has a basis because of that positive test to find that she's not meeting the conditions. And then under subsection I2B of that court rule, I think the burden then shifts to the defendant because it states that the defendant has to show that there was compliance or that compliance was impossible through no fault of the defendant. So once there's an initial showing that there's been a violation, which again there was in this case, then it's up to the defendant to show that it wasn't a violation. It's not up to the court or the prosecutor to prove that there was a violation of the bond. Otherwise, the court can continue the revocation. And so that's where we're at. So I think from a procedural standpoint, there wasn't anything improper or foul of the court rules. Looking at the bigger picture now, as Mr. Nichols has indicated, Ms. Welch has pointed out that I think you could benefit from treatment. And I agree with Mr. Nichols' proposition generally that part of the court's role in a case like this is to consider rehabilitation. I think, and I agree with Mr. Nichols that everybody deserves that opportunity. The question is, when should they be given that opportunity given their circumstances? You've had some opportunities at that already. You've been on bond in this case a long time. You tested positive a couple different times. And so my view is that at least at this point, while this is still pending, you've been given those opportunities. They haven't worked out. So now is not the time for further opportunities. If you are convicted eventually by a jury or otherwise, the court will absolutely consider, to the extent that it's possible. I don't know what kind of consequences you'll be facing, but if it's local or community sanction, the court would absolutely consider treatment as part of the sentence in this case. But in terms of modifying or changing bond, again, in this case, to allow treatment prior to a resolution, I don't think that's appropriate because of your history. So the court is going to deny the motion to modify the bond, and we'll proceed with the case as scheduled. In terms of the motion to withdraw, Ms. Welch, is that correct? You're asking to have Mr. Nichols released from the case?
Yes.
Okay. Mr. Nichols, I did not see an order, a proposed order withdrawing, but if you want to submit that, I'd be happy to sign that.
I will do so. I've got it right here. I'll email it, and then should I send a self-addressed stamped envelope to follow by US mail so that I can get this order and then the order on the bond back to?
Correct.
Okay, we'll do it.
And then Ms. Welch, did you want to hire a different attorney? Did you want to seek court appointed counsel?
Yeah, court appointed counsel.
Okay, so Mr. Thompson, if you could aid with Ms. Welch and do an evaluation.
I will. I believe at the very beginning of the case, she was screened and approved. And I was appointed, so I would just reappoint myself given her current situation.
Okay. All right. Do you have any questions about that? So. All right, thank you. That's all for this hearing today. Mr. Nichols and Ms. McGregor, you're free to disconnect at this time.
Thank
And
you, Your Honor.
I'll send an email to Mr. Thompson and give him whatever he needs.
Yeah, while we're all here, could you just tell me the next court date?
She is currently set for a final jury status on 1/9/25 and a jury trial on 1/13 and 1/14.
1/9/25 is a jury status conference, and that's the next court hearing. Okay.
Correct. And then the trial 13th and 14th following week.
All right. Does the court have a preference if I just do a substitution with Mr. Nichols?
Yeah, I don't have a preference, however it works out for counsel. If you want to do a substitution or if you want to do an order.
All right. Thank you. I'll give it to Mr. Nichols on the orders.
Absolutely. Thanks, Jason.
Thank you, Your Honor, for
Thanks,
allowing me to
everybody.
appear Zoom.
Okay, you're welcome.
Same here. Thank you.
You're welcome. Okay.
Can I go use the restroom, sir?
I feel like that might have been adjourned.
Mr. Mafalda just told me it was adjourned, but I don't have it written as adjourned either, Sarah.
I thought I might have been even yesterday.
Yeah, it was yesterday.
Okay,
And I
okay,
signed.
so we're done? Because Johnson is adjourned for sure,
There was a lot of stuff going on.
yes.
That's it, or is that?
So 11:22, I have it set for today. I don't, and then there was, that's all I have, setting it for today's date, so I don't have the.
I didn't ask for it, is Turner did.
Oh, we did sign it. I don't know if it got to you. Maybe this morning.
It was in my email or in the office. Apparently it's not home.
So that's it for this morning.
Correct.
All right, that concludes the court's morning docket. The court will be in recess until 1:30.
I'm here for failure to show for jury duty.
Did you check it in the window in the front when you came in?
Yes.
And they told you to have a seat in here? Did they give you paperwork to fill out?
No.
Okay, so I don't know if you have juries for causes today. You checked with Michelle when you came in?
I went to this window.
Yep, nope, you gotta check in with the window here at the clerk's office and she'll give you information there.
Okay.
I forgot to check in too.
Yep, so you're gonna need to check in with her as well.
Sorry.
It's okay.
I didn't know.
Because I don't know which judge is, we've got a couple different judges in different courts today.
Okay.
I didn't know about it.
Okay,